session. Parties and counsel are present. Our jurors that are not yet present. Counsel indicated you wanted to be heard on something before we resume with the jury.
Yes, Your Honor. Before we go into the last couple of areas, before we do that, I wanted to run it by the court and counsel. The next series of questions deal with documents found on the e-machine, and the three documents that we're referring to, the first one is a document found that deals with, let's see, it's a payoff. It says that it's the name of the file on the computer was Dan Money 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 sign with that sign, and basically it lists Dan payments, January 29, 2009, $1,000, January 30th, 2009, $5,000, February 15th, 2009, $100, and February 18, 2009, $200. These are payments that are listed. It was a computer file found on the e-machine.
Okay, what's the relevance to payments to Kavanaugh in 2009?
Because that's part of the buyout. That's our contention. It's part of the amount of money that.
So far, there's no evidence of a buyout.
I think there is.
Susan Blake indicated that that Joseph was going to be buying out Kavanaugh. She may have indicated that there were some payments already made, or
no. Your Honor, there was a check that a couple checks actually. One of them I think had a memo line of either buyout or payoff or buyout was the memo line that's been introduced. I think there was two checks of that nature, symbolizing the same thing. I'm not sure the same word was used. So. Yeah.
McIver McCarver also testified that he spoke to Joseph about that when he was paying during the week, that he was finally done with the buyout.
Okay, yes, I recall that. So, but if we have the checks, then we have the evidence of the payoff of the buyout.
Well, some of it, because Joseph made payments in other forms besides the check. This record here has 3 of the 4 payments are by PayPal.
And it's for the court to see what the document looks like, to your right.
All right, sure.
No, I mean, it's up already.
Okay, but this doesn't say that it's for a buyout or for payment for services rendered or for anything else.
Okay, so the name of that file is Dan Payoff.
Okay, so still, we already have evidence that Joseph was buying out Kavanaugh, and apparently evidence that the payments had either been almost completed or completed. So, that there's a file that says Dan Payoff that shows amounts being paid. It's cumulative. Doesn't have any additional relevance.
The additional amount, the additional information here, though, is there's 3 different payments from different sources. The only source that's in evidence now is the check, or checks, sorry, there's 2 checks that show buyout or payoff or something like that. One of them I know says buyout.
How is that relevant to who killed the McStays in 2010?
Because as the payments were occurring throughout 2009, these payments are all made at different times. So as you get towards the end of 2009, that's when McIver McCarver is able to say that either the payoff is complete at that time or close to being complete, and therefore Kavanaugh is not getting any more money from Joseph. In fact, if you look at the payments from PayPal at the end of 2009 and 2010, as I pointed out in the PayPal records, Joseph is only sending him very small payments. Okay, $50, $25, $100. They're very small payments towards the end of 2009, beginning of 2010. Dan Kavanaugh is broke at the time the family disappears. In fact, the bank records that we have for Kavanaugh that may already be introduced, I believe that they've already been introduced, showed a balance of minus $40 on January 31st. So our theory is that desperation that Kavanaugh was in, which was evidenced by, of course, the threatening instant message where Dan is wanting to be bought out, which started these payments, is a continuation of the behavior, the aggressive behavior, and the threatening behavior that Dan Kavanaugh was displaying towards Joseph.
And it should be noted that the threatening RTF, that the file that Joseph created, was dated 1/29/09, and that's the date of this first payment being made on the payoff as well. And then the second payoff was made the day later. So it all kind of wraps together, showing why Joseph was doing what he was doing.
The specifics as to the specific dates and amounts of the payments in early 2009, I don't think have any relevance.
2 checks were created in QuickBooks on February 1st, 2010, and then deleted. The district attorney has made a big deal about the fact that they're attributing that conduct to Chase. However, our position is that Joseph wrote and deleted those checks as demonstrated by the evidence we presented today. So if Joseph is writing those checks and deleting them, he has a reason to delete them too. And the reason he's deleting the checks is this is all being hid from Dan Kavanaugh. Okay? And why would he be hiding it from Dan Kavanaugh? Because he's being threatened by him. If the court were to
okay, I understand all that.
Okay.
But the specific relatively small payments in early 2009, I mean, I don't see the relevance of that.
Well, it's not just the beginning of 2009. They go on through the year. This is not. That's for the very reason. If you're saying we already have evidence, that's a contradiction. There's already evidence that there's a buyout going on. So doesn't it matter that the buyout continues through payments throughout the year, not just at one particular time? There may be evidence of a check at a given time, but I think all the payments throughout the year of 2009 matter, because that's when the payment is complete at the end of 2009, beginning of 2010. And Joseph was making payments since January 29, 2009.
And as part of the payments, also, one part of the exhibit that's on the e-machine is the bill of sale for the BMW that even Mr. McCarver testified that was given to Dan as part of the satisfaction. That's the other document that we have up on the screen that shows the bill of sale.
And that's
given to him as a gift.
That's March 27th, 09. That was also found on the e-machine.
I really don't see the relevance of it. You went through the other records showing all of the various payments going to, or sums of money going to Kavanaugh, whether it be PayPal or bank records.
Correct.
Shows the desperation of a man at the end of his rope and where it started.
And if you look at what Mr. Kavanaugh does on February 10th, he initiates transfers and makes transfers from Joseph's account to his own account over the next 3 days from September.
All of that is admissible. I agree with that.
Right.
I have no quarrel with you showing anything that Kavanaugh did with regard to the business or the accounts from February 2010 on. That he sold the business, how much he got for it, if he took money out of the business, all of that is, I've already indicated that's certainly relevant.
In Kavanaugh's interview with San Bernardino detectives, he tells San Bernardino detectives how he feels Joseph was screwing him out of all the custom business. The animosity that Kavanaugh has to Joseph is because he feels Joseph squeezed him out of the you see the numbers, Your Honor, 300,000 for the year of 07. Dan didn't get any of those commissions on that. And when Dan found out about it, that's when he went into his rage. He couldn't believe that Joseph had not paid him commissions on that. And he threatened him. And that's where that threat comes in, because he found evidence that he had a custom business with Chase. And our position is, Chase never knew about Kavanaugh. They didn't even know each other.
That's all good for final argument if you have evidence in the trial to support all of that. But these particular documents just showing payments in 2009 to Kavanaugh.
They don't just show payments. They show a file name of payoff, which you can infer that that's part of the buyout and the payoff to Dan. I mean, whatever you want to call it, a buyout or a payoff, Joseph was paying Kavanaugh because Kavanaugh threatened him. He would shut his business down and harm his family if he didn't pay him. That's the threat.
Okay, and Joseph gave in to that and paid him.
Correct. But
okay.
at the end of 2009, no more payments, all paid off, and Dan Kavanaugh has no job, no skills, no nothing. And he has no money.
Actually, no more threats of give me more money or I'll shut down your business. Correct?
If you don't give me more money, correct.
Okay.
That's exactly what he did. And so Joseph paid him off.
But after he was paid off,
Dan's broke.
But after he was paid off, Dan didn't say to Joseph, give me more money, give me the percentages that you gave to Chase, or I'll still close down your business. He didn't do that, right?
No. Well, I can tell you this goes to the other threat that the court excluded. He felt like he was screwed over in a business deal, and then the next person he did business with, the bodies were found. He said, people screw me over in the business deal. I know how to make your body, I know how to make you disappear. Your bones will be found in the desert. That shows later what he did is his admission to what he did to them. Right. So it shows the anger and animosity he felt.
I don't see the relevance to specific payments in a file called buyout in 2009.
And what about the bill of sale? Because that's a different document.
It's even less relevant. So it sold a BMW to...
Well, he gave it to him as a gift as part of the payout, which is what MacGyver testified to, and that substantiates that testimony.
However, the document before the court's unsigned. It's an artifact found on the computer. It's also hearsay as to the drafter. And it's more backdoor attempts to get into the third-party culpability this court has already excluded. The idea being, if you let this in, then the slippery slope allows you to do the other stuff.
Well, it is unsigned and it is hearsay, so...
The court doesn't like us making reference to what the court has ruled on as what is admissible to Chase. But we have a laundry list of material that the court has allowed in without question over our objection, including photos subsequent to these events of our client in the desert, digging out something in the desert. No problem, even though that's highly prejudicial. And there's a plethora of items that we could go on and on about, and the court doesn't like us to do that. But in reality, that's what's happening. All of this, when the court says it's not relevant, I fail to... The issue of whether it's not... It's clearly relevant, and it clearly corroborates our position. But, so I don't believe that relevancy is the right issue. If there's another issue, please let us address it, and we will. But relevancy, surely it's relevant. It involves this whole issue of what was going on at the time in Joseph's life. It was a major event in Joseph's life to be threatened by Dan Kavanaugh. He was scared. Joseph also went to authority domains and asked them to... that be ready because Kavanaugh is going to badmouth me, but I still want to continue to do business with you.
Well, you haven't put on any evidence of that yet.
We have that in emails that were written.
Well, the unsigned bill of sale, there's no foundation for it. It is hearsay. I would sustain the objection to that. We've gone through lots of other documents showing money flowing to and from the various parties. So I guess one more exhibit showing four other payments might not be particularly relevant, but it's certainly not prejudicial and not a very good consumption of time. So,
But it is hearsay.
well, I'm letting in.
I understand the court's letting in a lot of hearsay.
Well,
But-
I'm letting in the documents that pretty much demonstrate a business record of Joseph. I'm not letting in just statements, but if it's something that relates to this is what was occurring in the business, there was a say, this waterfall was for so much, the distribution of the proceeds was so and so, yes, I am letting that in. So.
Your Honor, there's also Exhibit 9, our Exhibit 9A, which is Exhibit 1051. It's a series of Google searches. It's a Google search history of Kavanaugh found on his laptop. Probation seized his computer in January of 2014, and when San Bernardino took it over, they took it over. They seized the computer. In there's searches starting in November of 2013. Bodies found on November 11th. Searches begin on November 14th of the bodies found in the desert. The McStay family. The searches go on about the McStay family. Significant searches about the McStay family. This is the same set of searches where you've already excluded the Fifth Amendment. This is part of that. We're not going to get into the Fifth Amendment. The court has already ruled on that. This is where Dan Kavanaugh does a search about the Fifth Amendment, and the court has already ruled on that. That's part of this, but we're not getting into that part of it. It's just the McStay family research or searches that Dan Kavanaugh is doing at that time.
At the time, shortly after the bodies were discovered.
Correct, and on through 2014.
And for the foundational issue, we have had subpoenas out to San Diego Probation Department for the officer that actually seized the laptop. They would not give us his office, and they said send it to our legal department. We hoped he'd be here last week, and then we got notification, oh, he retired, so we have to send it again, and then they'll forward it to his home. So we do anticipate them testifying. We do have the contact with the San Diego Probation Department to get him here. He just hasn't testified yet due to issues with his retirement, communication with the department.
There's multiple levels of problems with this. The exhibit that they have does contain the stuff the court already excluded, as well as stuff that really isn't relevant, such as how to clean alcohol out of a pee drug test, reference letters for the court, because he was on probation at the time. The other foundational issue is even if they get the probation officer, they cannot lay the foundation that this actually is in fact Dan Kavanaugh's laptop, because an examination of the contents actually show it predominantly belongs to a third party. He may have had it in his possession at the time he was at probation, but the laptop and its contents clearly belong to someone else, including the very intimate photographs between that person and a young lady.
That's true.
And I will also add that all of these searches are the same types of searches that this court excluded on Mr. Merritt's device.
We should point out, though, that all the information from the other one was the previous owner, and the dates of that clearly show that it's it proceeds. It's not like an interaction back and forth. It's an early searches. You can a clear marcation of where it changed, and then went all of a sudden from that point forward to
So is it unusual that if someone you know and have had business dealings with and has been missing and their bodies are subsequently found in the desert, is it unusual that people who knew them and had business dealings with them would be bringing up articles about bodies being found?
I don't know, would it be unusual if you have a friend of yours that was murdered to go visit the gravesite and take pictures there? No, but the court allowed that in so they can have a nefarious argument of what he was doing up there. I don't know what it is. They haven't explained what the relevance of it is. But the court allowed them to do the same thing about showing information about the deaths and after they died. We just want to do the same.
The standard of admissibility for evidence against a charged defendant is not the same as a very limited area of third-party culpability to someone who is not charged. I don't see that it has any relevance.
The standard against omitting information against a defendant is if it goes to prove guilt that is not prejudicial in this presentation. The evidence that's submitted on third-party culpability, if it's in any relation to show, to raise a reasonable doubt. And so if it has any relation to raising a doubt to the guilt of the individual, then it's just as admissible.
All right, the information on the computer about searches, about the bodies, the remains being found in the McStay family and such, I find is not relevant, so I sustain objections on both relevancy and evidence code 352.
Your Honor, on that same list of searches, there's 2 searches in July of 2013, before the bodies were found, regarding the McStay family. What about those? And then also, in addition to that, mixed in with the searches for the McStays, there's also searches regarding Charles Merritt, beginning on November 17th, 2013.
Again, I don't see any relevance to that, so I would sustain objections to that on relevancy grounds and evidence code 352.
So, just to be clear, the payment.
The one exhibit with the 4 payments in early 2009, even though I don't think it's particularly relevant, it goes along with the rest of the information as to various payments going to or from Mr. Kavanaugh, so I'll allow it.
Okay, thank you.
So 1054, which is 9A, is out. The search terms. Which are the ones? If
the only one that we
Rock knows up there, if we can turn them over on the.
It's 1025 is the only one the court said that can come in.
1025 comes in. The one about the bill of sale, the one that's out for Lack Foundation, what's the exhibit number on that? So we just have it clear.
That's a 1024.
And then the last one on asking the court to reconsider it's the threats IM chain. Is the court going to change its ruling on that one?
No.
Okay. And that one is?
That is 1023.
Okay. You ready to bring the jurors in? The record reflect we are back in session. Parties and counsel are present. We move to our jury and our alternates are present. And our witnesses back on the witness stand. And when you may continue your examination.
Thank you, Your Honor. And I'm almost done. Just a couple more questions. If we could go to 2C, which is exhibit 1025. Okay. Do you recognize this?
Yes, I do.
And what are we looking at?
We are looking at an email, and with subject line re as in regarding Dan, $$. The date of the email is April 29th, 2009. It is from Joseph at earthinspiredproducts.com to eipfountains@yahoo.com. And it has an attachment of danpayoff.xls.
Do you know what our Joseph McStay, our Joseph at earthinspiredproducts.com, who is that email sending, who's eipfountains@yahoo.com?
From my examination of the computer and going through the emails, it's Joseph has emails from various accounts. These are 2 accounts that I saw. So this appeared to me to be Joseph sending himself an email.
Okay, and it has an attachment?
Yes, danpayoff.xls.
Okay, and this has a date associated with it?
Your Honor, based on the witness's last answer, I'm going to renew my objection as to relevance, given the context of this exhibit, if it was sent to himself.
Overruled.
Has a date associated with it?
Yes, the date of the email was April 29th, 2009.
And this was found on device 4, which is the e-machine?
That's right.
Okay. And we have the second page of this exhibit. Basically, an email sent to himself with the attachment.
Yes, correct.
Okay, then page 3.
Is the attachment.
Okay. And it has a second page, and what are we seeing here?
So these are the contents of the attachment. This is the Excel spreadsheet. It's entitled Dan Payments. It has 4 dates, $4 amounts, and notes for those.
Okay. So on January 29th, there's it looks like a $1,000 PayPal. January 30th, $5,000 check. February 15th, $100 PayPal. And then February 18th, 2009, $200 PayPal?
Correct.
Okay. And finally, we had talked about device 3, which was the laptop. And I had asked you a question, and I apologize, I didn't probably ask the right question in terms of the computer name. I had asked you whether Detective Schrader had given a name or associated a name with that computer. First, let me ask you, is that device 3 is not the Giuseppe lap that you referred to earlier, correct?
That's right.
As far as you know, the Giuseppe lap is missing, or you don't have it, correct?
Correct. And none of the computers that were provided, none of the computer images that were provided to me were Giuseppe lap.
Okay. And did the device 3 that we looked at, did that have an internal name? And if I'm not using the right terminology, please correct me.
Computer name is fine.
Okay.
For that, it did have an internal name.
And how does a computer get an internal name?
When you get a new computer or install Windows, when you set up a new computer, one of the first questions it asks you is, what would you like to name this device? When you do that, that name is recorded as the name of the device.
Okay. Do you recall what the name was of device 3?
I believe it was Summer PC or something similar to that. Unfortunately, I don't remember the exact name as I sit, but I definitely know it was not Giuseppe lap.
Okay. Thank you. Nothing further.
Cross. Sure.
Good afternoon, Mr. LaRock. How are you?
Good afternoon. Doing well. Thank you.
So, you indicated on direct examination yesterday that you were appointed by the court. Do you have a copy of that court appointment?
Not with me right now.
Isn't it true you were hired by the defense?
My understanding, I may have some limited knowledge as to that. My understanding is that we were appointed by the court.
Who from the court contacted you to say, please come in and work for Mr. McGee and Mr. Malik?
Looks like, I'm sorry, Your Honor, objection is misstates the evidence as to the date he was appointed
Overruled.
and the date we came on the case.
Overruled.
Who from the court contacted you and asked you to work on behalf of the defendant?
When my company first started working on this case in late 2015, originally my partner at the time, another examiner by the name of Sherry Katz, originally started working on this case. She was working, as I understand it, with Raj Maleen and his office. My understanding from what Sherry told me, as well as documents that I've seen authorizing our funding, are that these are that the court appointed our company.
My question, sir, was who from the court contacted you to work for Mr. Maleen, his law firm, on behalf of the defendant then?
Me personally, or
Your
Illumina
firm.
Discovery, my company?
Your firm.
I don't know the answer to that question. The initial conversation was with Sherry Katz.
Isn't it true you were hired by Mr. Maleen's law firm to work, and that the court doesn't make such appointments?
I don't know the answer to that one. I'm going off of my understanding from Sherry Katz.
So was your representation that you were court appointed intentionally designed to boost the perception that you are impartial?
Your Honor, I don't object. Now this is argumentative.
The objection is argumentative is sustained.
So how much are you being paid for your services since 2015?
My company is charging $350 per hour.
And how many hours have been billed since 2015?
I don't have an exact number. It's definitely more than 300. I believe it's more than 350.
You'll do the math for me. How many? $122,000 since 2015,
That's correct, for my company,
roughly, give or take.
roughly.
Okay. And the scope of that work started in 2015, correct?
That's right,
And you wrote a report in this case.
I did.
And I noticed that your report does not include a date in which it was drafted. What date was your report drafted?
I began work on the report in September of 2018, and it continued after that time.
My question, sir, was when was your report drafted?
My report was drafted between the period of September 2018 and this month. And as of, I believe I completed it this past weekend.
And so you did not disclose it to anyone other than the defense team until 4 o'clock Monday morning, isn't that correct?
I provided the report to Raj Maleen on Sunday evening. He said that he needed to provide that to your office.
But you personally emailed it to me and Mr. Dougherty and Ms. Rodriguez at 4 o'clock in the morning on Monday, right?
No, that's not correct.
Okay. We'll get the email and verify it. Maybe was it 3 in the morning?
Would you like me to explain?
No, I'm asking you, was it 3 in the morning or 4 in the morning?
Neither.
Okay.
The email contained exhibits, not that report.
Oh, so you surprised us with your exhibits at
Objection
4:23.
argumentative.
The objection,
Can we approach on this?
No, the objection sustained is argumentative.
And
So
counsel
the-
should really be admonished at this point, Your Honor.
The objection is sustained is argumentative.
You prepared exhibits in this case. When did you prepare the exhibits in this case?
Again, the exhibits were prepared over the course of several months. They were finalized this past weekend.
And so, you didn't turn them over to us until 4 o'clock in the morning on Monday, the day you were supposed to testify.
That's correct.
Were you attempting to gain some type of advantage by waiting until 4 o'clock in the morning to turn those over?
Objection, argumentative.
Objection sustained on relevancy grounds.
Yet, your firm has been working on this case since 2015.
That's right.
And are you aware that material from your report was included in court filings by the defense months and months ago?
Objection.
Now, we're assuming facts, not in evidence.
Sustained.
I'd ask the court to take judicial notice of the defendant's motions.
The objection sustained on relevancy grounds. And beyond the scope of this witness's knowledge and information.
In the world of criminal cases, you've handled how many cases?
I can give an estimate. I personally have probably worked on, I would estimate somewhere between 75 and 100 criminal cases.
How many were for the federal public defender?
The federal public defender, I don't know that as I sit here. Again, I could try to estimate.
It's important on your resume to list the scope of work that you have done over the years. Wouldn't that be fair to say?
I think it's important to list examples of the work that I've done.
And so, in the criminal world, you worked for the federal public defender, the Orange County public defender, the Riverside public defender, and several private defense firms. Isn't that correct?
That is a portion of the work that I've done, yes.
And has your firm ever been used or utilized by a law enforcement agency?
By a law enforcement agency? No, we have not. Not to my knowledge, at least.
Or prosecutorial office?
Same answer.
And for some reason already, even though you just did your testimony this week, this case has already hit your resume, hasn't it?
That's true, yes.
So it was important to update your resume for work you hadn't even completed yet because it was a capital murder case, right?
Objection, argumentative.
Sustained.
Well, why did you add it to your resume prior to even completing your work on this case?
Objection, relevant.
Sustained.
So what was your understanding of the purpose of your work in this case?
To examine evidence provided to us, the forensic copies, and specifically to try to locate information to give more information as to what was happening at this time period, especially around the lives of the McStays, their associations with other people, especially the defendant, Chase Merritt, to try to ascertain what happened, what were the circumstances of their disappearance, what were the circumstances of their murder, if such could be learned. Basically, to try to give as much truth as possible as to this case.
So you were out to solve it?
Objection, argumentative.
We were out to provide as much information as we could relating the mysteries of the case.
So you're here to solve mysteries?
Objection, argumentative.
Sustained.
So, you would agree that someone who's involved in computer forensics one of their primary tasks is actually just look at the evidence, correct?
By look at the evidence, could you clarify, please?
To analyze and tell us what the contents of a device is. Wouldn't that be it?
That's part of the task, yes.
To tell us what the data is on behind the metadata on a photograph or a text message, correct?
It depends on the circumstances and what we're doing in a case, but those are frequent activities, yes.
Right. And those are objective observations that you would make as a forensic examiner, correct?
I'd agree.
At what point in being a forensic examiner is it appropriate to then become subjective?
I'm not sure I understand your question.
Well, you would agree that to be honest with the role of a forensic examiner would be to be objective as to what the evidence is, correct?
Yes, absolutely.
So, coming to a task with a subjective interpretation of evidence would not be truly being objective forensic examiner, would it?
Your Honor, this is the line of question that's totally argumentative.
I'm failing to understand why you're bringing up subjectivity.
Well, sir, isn't it true that on multiple occasions, well, you just testified that part of your purpose for working in this case was to provide context and meaning as to the mysteries of this case.
Correct, from an objective standpoint, to provide
But isn't that
evidence for
subjective? Aren't your conclusions subjective?
I believe my conclusions are objective.
So when you say something is, quote, extremely compelling, that's an objective look at something?
Yes, I agree that it is.
So the use of hyperbole, such as extremely compelling, is remaining objective to what the facts actually are in your mind.
Yes, in many instances of what I have to do and in my job, you don't always have a record that says one thing happened, one thing did not happen. You often have to look at context. My job is, a huge portion of that is looking for context to learn from the objectivity of the context what information may be important for a case.
But the problem is, you're a forensic computer examiner,
Objection, argumentative.
if I may finish my question.
The objection sustained is phrased.
However, as a forensic computer examiner, isn't your job to analyze what the data is and tell us what the data is on the device without choosing sides?
I believe that's a portion of my job.
So you believe part of your job is to come in and take sides then?
Objection, argumentative.
Sustained.
Who gave you the context and meaning of what to look for?
I hope this answers your question. Forgive me if it does not. I believe it does. My initial instructions for the case were provided to me, in this case, through my partner, Sherry Katz, who initially spoke with Raj Moline.
So it was the defense that gave you the context and meaning that they wanted to see from your forensic analysis.
Objection, argumentative.
Sustained also calls for speculation and conclusion.
That's your state of mind is your directives came from the defense as to what to look for and what its meaning was.
I don't think that properly represents what I just said.
Well, if I understand what you just said, was that instructions were given by Mr. Moline or his group to Sherry Katz, which was then conveyed to you. And that was your understanding of your task at the time you took it on, correct?
That instructions were provided to examine the evidence in the context that I just provided, to provide factual data for the case.
So you were asked to analyze evidence in a particular context.
We were given information about the case. We were told what the case was. We were told who the defendant was. We were given information by your office, the police reports, etc. We were.
Well, let me stop you there for a minute, because.
Well, if you could finish, Your Honor.
Overruled, you can ask your next question.
Who from my office did you personally receive something from?
I received the information, the data actually from Sherry Katz.
Okay, well, you represented multiple times in your testimony that you received evidence from the district attorney's office. Who from the district attorney's office did you get that information from?
I don't know where the information came from in that case. It was provided on, well, actually, I do know some information. The information was provided, I believe, on a thumb drive to Ms. Katz, and in conversations with Sherry Katz and with Mr. Moline's office, my understanding is that was provided by your office.
So you don't know, is what you're saying?
Objection argumentative.
Sustained.
If I take it from your answer, you have no personal knowledge as to where the evidence you analyzed actually came from. Would that be fair to say?
Your Honor, can I object to this whole line of questioning in 352 relevant?
I don't think that's accurate. I have information from Ms. Katz as well as Mr. Moline as to where this evidence came from.
So you have no personal knowledge. You didn't receive it from someone in my office handing it directly to you, or see us handing it to them, or to Ms. Katz.
I did not.
You're relying on hearsay.
I'm relying on information provided to me by other experts. Right, by another expert, my partner.
So the question begs why you repeatedly, in your answers, said that it was information received from the district attorney's office when you didn't know that.
I believe I forgive me if I'm wrong, I believe that I am able to rely upon the information that I received from another expert, my partner Sherry Katz.
My question is, did you intentionally portray it as receiving it from the district attorney's office in order to provide some credibility to your answers?
Again, Your Honor, this is argumentative. Can we approach on this?
The objection sustained is argumentative. The request to approach is denied.
So along these lines of your scope of duties, as part of that, you created these notes that I asked for during the middle of your testimony before lunch, correct?
I believe
Sorry.
I know what you're...
Let me get closer so you can see what I'm holding, but
Okay.
correct?
What, could you repeat the question now, please?
You created this for your testimony, correct?
I created that to prepare for my testimony, yes.
And is it common for you, as an objective forensic evaluator, to prompt notes as to questions and discussion topics?
Yes, I think it is.
Now, as part, obviously, we've learned that you've inherited this case. What day did you actually inherit this case? From Ms. Katz.
Ms. Katz was primarily working on this at the very, very beginning. I was assisting her at that time. Ms. Katz, my partner, officially retired. I believe either in late 2006 or 2007, and it was at that time that I officially inherited it as the primary examiner.
During the course of your testimony, you referred to multiple pieces of evidence. But I note in your report you do not list the actual evidence that you received. Can you please describe that for us now?
The evidence that was received by my office, for which I've done the examination.
Well, did you receive the entire case file?
I'm not sure which case file you're referring to.
Well, let's start with Detective Schrader's report. Did you receive his entire report?
I received multiple batches of reports over time. Mr. Schrader had many reports. So the ones that I looked at, to my knowledge, they were complete reports. They appeared to be complete reports, but I don't have a way of knowing if I received absolutely everything.
Did you read all of Detective Schrader's reports?
I did not go through every page of the thousands of pages of reports.
So, Detective Schrader's report was important to you as kind of a starting point as to the analysis of these devices, wouldn't you say?
Objection, argumentative.
Overruled.
Yes, I'd agree that his analysis was a good starting point.
But you didn't take the time to read all 21,000 pages.
That's correct.
Were you provided a copy of the defendant's cell phone records?
The defendant's... yes, I was. Oh wait, the defendant's cell phone records? Sorry, I was confusing that with Joseph's cell phone records. I was provided with a forensic image of the defendant's cell phone.
My question was, did you receive a copy of the defendant's phone records?
I believe that there was a copy of cell phone records of the defendant in the reports.
Did you review them?
I did to some degree, yes.
But you chose not to use them in your analysis of the evidence in this case, correct?
Objection, argumentative and relevant.
Overruled.
Could you repeat the question, please?
But you chose not to use them in the evaluation of the evidence in this case, correct?
I relied upon what I saw in his reports as I was going through the evidence, examining it on my own.
What reports? We're talking about phone records, sir.
Reports that Detective Schrader extracted of cell phone records.
Okay, let me start over again. Did you receive a copy of the defendant's AT&T phone record for the 909 number that you referenced multiple times during your testimony?
Oh, I understand what you're saying. I do not know if I received those records.
Don't you believe it would be important if you're going to analyze forensic evidence and compare it to other evidence that you should have a complete record of that evidence?
Objection, argumentative.
Overruled.
That I should have a complete record of that evidence.
Yes.
I believe that I had evidence related to the cell phone. If I didn't have the complete evidence, I'm not sure if I had all the complete evidence.
Well, you went to some painstaking detail comparing certain PayPal or QuickBooks activity to Mr. McStay's phone records. Did you do the same for the defendant's phone records?
Looking to see... I think some context as to what I was doing was important to answer that question.
The question's very simple, sir. Did you refer to the defendant's phone records? Did you receive them? Did you refer to them in this case?
I referred to phone records to try to ascertain the person who was logging in to Joseph McStay's QuickBooks Online activity at this time to see if it was consistent with Joseph McStay.
Was that part of the subjective agenda that you were asked
Objection,
to look for?
argumentative.
Sustain this argument.
Okay. My question still remains. Did you refer at all to the defendant's phone records?
Objection asked and answered.
Actually, it has not been answered.
Overruled.
I do not recall if I referred to those records at a point in my examination.
You spent a lot of time talking about the PayPal activity and referring to two specific exhibits. Did you take the time to review the transcript of the testimony of Mr. West or Sergeant Hankey regarding the QuickBooks activity?
I did not. I'm not aware of the testimony to which you refer.
Oh. Did you receive a copy of the transcript of Detective Schrader's testimony when he was brought back the second day to talk specifically about computer activity on the E-machines and HP machines?
Computer activity on the E-machine and HP?
Yes.
Well, I was there for that testimony.
You were there when he was brought back the second time?
Perhaps I'm misremembering. I'm not sure what you're referring to. I apologize.
So you're not aware that Detective Schrader was brought back a second day to clarify an issue?
I was present for 2 days of Detective Schrader's testimony. When you say brought back, I'm not sure if the second day is what you're referring to, if you're referring to a third day.
Do you recall specifically, whether you were here or not, Detective Schrader's testimony regarding activity on the E-machines on February 1st?
As I sit here, I don't recall if the testimony that was there for February 1st. I don't recall Detective Schrader's testimony on that.
Well, you've made a point to talk about the PayPal activity that occurred on February 1st. Don't you believe it would be important for full context to recall or have available that testimony from Detective Schrader regarding what activity he found on those machines on February 1st?
Your Honor, that question is now argumentative. He's testifying to what he saw.
The objection sustained this phrase.
Were you made aware, if you weren't here, were you made aware that Detective Schrader specifically testified that there was no QuickBooks activities found on the E-machines on February 1st?
Oh, I apologize. Yes, I do recall that testimony.
Now, other than what would you like to talk about next?
Objection, argumentative.
Okay.
Sustained.
Let's talk about this. There's other materials in this case. You indicated you analyzed 9 computers.
Approximately.
But you don't list those in your report, so how do we know what computers those are?
I can describe them from the best of my recollection.
Well, we have the HP, right?
Correct?
We have the E-machines,
The E-machine, right?
and we have the laptop, the HP laptop, right?
The Dell laptop.
Or sorry, Dell laptop.
Dell laptop.
Okay. Those are the three McStay computers. Did you analyze some other computer associated with the McStays?
Yes.
The McStays.
Yes.
Which computer was that?
There was a computer, I think an Acer, that was used by Jonah McStay.
Okay. Is there another one associated with McStays?
I believe that's the end for McStay's.
Okay, so that's 4. Is there a reason why you didn't include that specificity in your report?
For my reports, I included what to me were the most prominent findings.
Were those prominent findings as defined by the defense?
No.
Objection argumentative.
Overruled, answering. Let me interrupt you. It's almost 4:15. We'll go ahead and take our evening recess at this time till 9:30 tomorrow morning. Keep in mind the admonitions previously given to you, not to form or express any opinions about the case, not to discuss the case. And again, that means not discussing anything about the case, witnesses, testimony, exhibits, parties, or attorneys. And we'll see everyone back 9:30 tomorrow morning.
Mr. Imes is misrepresenting the facts, trying to mislead the jury. When Mr. LaRock talks about I received that information from the district attorney's office, a hard drive was provided to Mr. Doherty, who imaged the entire discovery for him and we gave the hard drive back. So the discovery actually was provided by the district attorney's office as they arranged for that to be received when they imaged all the information for him. Second, the unprofessional tone and nature of the questioning to this point is highly objectionable. When Mr. Moline did something greatly less than that, he was admonished by force by the court in front of the jury, and the court is not doing the same thing to Mr. Imes, who is really treating this like a joke. And I think it's unprofessional, and I hope that this continues. The court treats Mr. Imes the same way they treated Mr. Moline on a prior occasion.
I would treat any attorney the same for similar conduct.
And I would assume then the court doesn't feel mocking not only our witness, but mocking me personally in his line of questioning. That doesn't rise to the level of an admonishment in front of the jury?
I think, well, I sustain many of your questions as, many of your objections as argumentative as phrased. But I think counsel on both sides are entitled to be aggressive and questioning of witnesses that they're cross-examining.
I would add for the court too that when you did admonish Mr. Moline about his cross-examination, it was because he actually mocked the court when the court.
That's why I said I would treat similar attorneys similarly for similar conduct.
And also, we have seen it multiple times from the prosecution, when their objections are sustained, they just start testifying, and we have to keep standing up and objecting and interrupting them.
Well, both sides have done that throughout the trial.
I do not believe I've ever done that. I may have made argumentative, but I don't testify.
I think both sides have done that, and I have sustained the objections when they're made when that's done. Okay?
I think that what this particular prosecutor is doing is it goes beyond unprofessional. When he mocks the witness and mocks me in my line of questioning, I think that goes beyond what is considered aggressive or normal. I'm not sure the court admonishes or tells us every time we bring up something or something is sustained against us, we like to bring up the counterpoint. It seems like the court does the same thing when we bring up the conduct of these prosecutors. The court doesn't do anything other than remind us of our missteps. So should we not bring up these issues? I mean, it doesn't appear, and as long as the court treats it that way, we're gonna continue to hear the type of stuff that we're hearing now. That's just my perception of it, and that's what's gonna happen.
All I can tell you is I sustained the vast majority of the defense objections as being argumentative or irrelevant.
Can a prosecutor continue to be argumentative, and you're sustaining the objections, obviously, and it doesn't change? So the sustaining of the objection should correct the behavior. It's not, and it continues.
Well, there is a line between argumentative and aggressive questioning, which calls into question the information that the witness related. And I would agree that if it was repeated argumentative questions that are being sustained and being repeated, then I would admonish counsel on either side for that conduct.
It seems to me like I lost count after 15, but whatever the number is, it seems like that's repeated conduct. Because it's the tone in which he's delivering it, which is a mocking tone of the witness. It demeans the proceedings, it demeans his office, and I just think it's a bad way of doing it, and if the court is not going to take corrective measure, then we'll just have to deal with it in that fashion. But I disagree with the way that is proceeding, and if counsel wants to continue that way and there's not going to be corrective action, we just have to, I guess, deal with it on a question-by-question basis.
Okay.
9:30?
9:30.
And you're